Next case is also the last case, People versus Parks. This is a 15-minute mini oral argument on the application. And if you are ready to proceed, counsel, you may.
Good afternoon, Chief Justice, Your Honors, and may it please the Court. My name is Angeles Meneses, and I, along with co-counsel Jessica Zimbelman and Garrett Burton, represent Kemo Parks. Kemo Parks is currently spending the rest of his life in prison for the act of passing a gun to his cousin and co-defendant, Viviano Harris. Mr. Parks did not shoot or kill the decedent in this case, nor was he present when the decedent was killed. But because Mr. Parks was 18 years old at the time of this incident, the trial court was required to impose mandatory life without parole, and they were thus unable to consider the hallmarks of youth in imposing a fair and proportionate sentence. I welcome this court's questions at any time. Your Honors, mandatory life without parole for young adults like Mr. Parks is disproportionate under this court's precedent in Bullock and Lorenzen. It precludes consideration of Mr. Parks' mitigated culpability and the circumstances of this offense. Mandatory life without parole is also disproportionate when automatically imposed on young adults like Mr. Parks, who the law protects from harsh penalties in other contexts. Mandatory life without parole is a punishment imposed in a minority of states. And finally, Your Honors, mandatory life without parole in this instance does not advance rehabilitation of individuals like Mr. Parks. Because Mr. Parks was 18 at the time that he was sent to prison for the rest of his life, he will spend more years and thus a greater percentage of his life in prison than someone who is an adult or beyond a young adult with life without parole. His brain development and heightened brain plasticity continues into its mid-20s, and thus it is arbitrary here to draw the cutoff line at age 18. Mr. Parks' brain development at the time of this offense contextualizes his behavior. He was aware that his association with his cousin and co-defendant could get him into trouble, but he was always with him anyway. He admitted that he knew that Mr. Harris planned to kill the decedent in this case, ostensibly as revenge for killing his cousin, yet chose to be with him on that day anyway, and chose to pass him a gun on that day anyway. Mr. Parks was more vulnerable to negative influences as a result of his age and outside pressures, including from both his family and his peers. Both were present in the vehicle that day. Mr. Parks was surrounded by his peers as well as his cousin, and he lacked the ability to extricate himself from this horrific crime-producing setting. Furthermore, Your Honors, as to the second Bullock factor, young adults like Mr. Parks are protected from this kind of harsh punishment in other contexts as well. There is a societal consensus regarding all of this. We can look to the drinking age in this country, the fact that now tobacco is prohibited for 18-year-olds and has been extended to 21-year-olds. We can look at HIDA, and we can also look at the fact that many states have now changed their definition of youthful offender to include those up to 21, 26, or some age in between.
Doesn't that, though, support the position that those are all acts the legislature took, and that is where that responsibility lies?
Your Honor, respectfully, I would say that it is not the legislature's responsibility to determine whether or not mandatory life without parole is constitutional as applied to young adults like Mr. Parks. This court has taken acts of the legislature previously and deemed them to be unconstitutional. Just last year with the Sex Offender Registry Act, for example. And so this court can also do that here. It can look at the Bullock factors and determine that mandatory life without parole is not proportionate under Bullock, and therefore it's unconstitutional.
What is your position on how do we draw a line, and or address the concern that line is just going to continue to move if we move it here?
Your Honor, I would answer that very similarly to my colleague who just argued before me. The line should be 25 years old, and what is in support of that is not only the evolving standards of decency, which this court recognizes as crucial to the analysis in Bullock, but also the science. The science has changed significantly since a decade ago when Miller was decided. And so now that we know more about adolescent brain development, young adult brain development, this court should decide that in light of those factors, that mandatory life without parole is unconstitutional for young adults like Mr. Parks. It may be that the science evolves one day And we're here again on a different case and a different age. But currently, the science supports drawing that line at 25 years old. There are only a handful of offenses in Michigan for which life without parole is mandatory, that being first-degree murder and other crimes that involve, for example, repeated sexual assaults of children under 13, or that endanger the lives of many people and result in death. To the third bullet factor, Your Honors, mandatory life without parole is a minority position. 32 states in this country take a different approach, and only 18 states follow Michigan's approach. 26 states and the District of Columbia don't mandate life without parole, and that's in any context. That's not solely applied to juveniles. 6 more mandate it only when aggravated circumstances are proven. And the Supreme Court of the United States prohibited life without parole for juvenile non-homicide offenders when 39 jurisdictions permitted that sentence, and banned mandatory life without parole for juveniles even though 29 jurisdictions permitted it. So even if there was that majority, this court could still take that action and find that in light of the bullet factors and the science before it, that mandatory life without parole is unconstitutional. But here we have a different situation in that a minority of jurisdictions find mandatory life without parole. Finally, Your Honors, mandatory life without parole completely eclipses rehabilitation for young adults, like Mr. Parks. In order to be constitutionally proportionate, a punishment must be tailored to one's personal responsibility and moral guilt. A mandatory life without parole sentence completely eclipses that. Mr. Parks' youth and other individual circumstances, like his home life, the pressures of his peers, to name a few, mitigate his culpability and reduce his blameworthiness in this offense. Also important to note again is that Mr. Parks was not the shooter. He was not present when the decedent was killed. Mr. Parks was convicted as an aider and abetter for the act of passing a gun to his cousin alone.
When you say he wasn't present, he was in the store. They parked outside the store. He was in the store.
Yes.
He had passed the gun to him during this exact episode. And then for the few moments while he was in the store, the shooting happened outside. Is that what you mean?
Yes, Your Honor. He was inside the store and the shooting took place in the parking lot.
The evidence certainly suggests that when he passed the gun, he had an idea of what the gun was going to be used for, does it not?
Yes, Your Honor. With the jury's verdict, they did find that Mr. Parks shared his co-defendant's intent when passing that gun in order to constitute aiding and abetting to first-degree murder. But that's only one factor to consider here. Again, we have to look at all of the circumstances of the offense and also the factors of youth that Miller has asked us to look at when looking at juvenile offenders. And here, those facts point towards mandatory life without parole being disproportionate.
This analysis you're asking us to undertake and the rapidness with which you have suggested the science is evolving, should we then expect that every 5 years or so we're going to be or maybe every day now, we'll be scrubbing the Michigan compiled laws under this clause to determine if they comport with whatever the state of the art is or the state of the science at a particular date and time? Is that the task that courts are going to be undertaking from now on since Miller? Is that what the Supreme Court was suggesting at that time?
It's difficult, Your Honor, because we can't predict how the science will evolve in the future and what will come in days to come. But here and now, we do know that the science shows that line should be drawn at 25, and that taking all of those hallmarks of youth into consideration and taking the circumstances of the offense and all of the factors that Miller has asked us to look at, this sentence, as applied to young adults like Mr. Parks, is disproportionate. And here is a textbook example, with Mr. Parks being convicted as an aider and abetter, not being the shooter. None of those factors were allowed to be considered because the law required that Mr. Parks be sentenced to mandatory life without parole. He will not have the chance to leave prison. He will not have the chance to demonstrate that he is rehabilitated. All of that is foreclosed because of this mandatory life without parole sentence.
The one thing I find interesting about cases like this is we're asked to accept the so-called science as though it were just a matter of fact. It hasn't been a fact litigated in court, even though we litigate scientific evidence often, but it hasn't been litigated in this case. And as we've learned recently with the pandemic, often what they tell us is the science has been wrong, and usually by 180 degrees wrong. So what happens if the science is wrong, that we have not contested in this case or litigated, turns out to be wrong? What happens then?
Your Honor, I would argue that in this situation, the science is not wrong. It overwhelmingly proves that that line should be cut off at 25. But the science is only one factor for this court to consider when determining whether or not mandatory life without parole as a sentencing scheme for young adults like Mr. Parks is unconstitutional.
And if young people can't be responsible for their decisions until age 25, are we going to start holding that they can't be responsible to make all other sorts of decisions that society allows them to make and be obligated to enter into contracts and make medical decisions and do all sorts of things we allow young people to do? Don't those, the science keeps evolving, that they're not responsible for decisions. How would it be fair, for example, to hold somebody to a contract that they entered into at age 22?
Respectfully, Your Honor, if this court holds that mandatory life without parole is disproportionate and that it is not, is unconstitutional, that is not absolving Mr. Parks and other young adults like him of responsibility. It is merely asking trial courts, when imposing a sentence, to consider, in light of his youth, in light of those hallmark circumstances, what his potential for rehabilitation is, things of that nature, and is allowed to consider that in fashioning a proportionate sentence for Mr. Parks that does punish him for what he's done, but also recognizes that as a young person, his brain is still developing. He has that capacity for change. But mandatory life without parole completely eclipses that. They are not allowed to, the trial courts are not allowed to consider that at all. And also I would reference an earlier response from my colleague as the second part to the answer of the question. Not all decisions made by young people are deemed null and void because of their youth. We're looking at different parts of development of the brain. There's the cognitive aspect, and then there's a decision that looks at what risks are involved in making a decision, the emotional component of making a decision. That's different than signing a contract or making a medical decision. We're talking about a decision where Mr. Parks put himself in a risky place, was with his cousin, was with peers, made the poor decision of handing a gun over, and now has to spend the rest of his life in prison and does not get the chance to rehabilitate. And so this is a different situation that we're looking at here. Your Honors, if there are no questions, I will reserve the remainder of my time for rebuttal.
You may do that.
May it please the court. Michael Tesner on behalf of the people, the appellee in this case. This was not a simple case of the defendant handing a gun to his cousin and then his cousin going off and doing something with it. They started out in the same location as the victim. The victim's vehicle was known, at least to the people that lived there. They followed the victim, the circumstantial evidence would show, they followed the victim to a party store. While in the back seat of the car, the defendant knew that Mr. Harris wanted to kill the victim because he believed that he had something to do with killing one of their other cousins. And he gave him the gun to do it. They went in the store together. Mr. Harris pulled up a bandana over his face, went outside, and executed the victim. And he aided and abetted in a first-degree murder. So is life without parole a disproportionate sentence to someone who aids and abets, enables someone else to commit a first-degree murder? That's the question here. And it isn't, the question really isn't, is an offender fully developed as an adult to make decisions? It is whether the person is developed enough to make those decisions. The U.S. Supreme Court drew that line at 18. And as there have been questions in this case and others, the 18-year-old line is a societal line. There's a lot of rights and responsibilities that people get in this state and in the whole country when they turn 18. They have the right to vote. They have the right to get to marry. They have the right to have children. In fact, they are able to be hired as child care providers at daycare centers for our children, for other people's kids. There's a lot of responsibilities that 18-year-olds have. I have 2 kids that are in their 20s. Neither one of them thought that it was okay to kill somebody. I mean, at any time, but especially after you turn 18. I don't know any of their friends who think it's okay to kill anybody. In fact, most adults don't kill people, and most young adults don't kill people either. So the question, as I said, is not, there's no magic line. The brain does continue to develop. Even the Supreme Court recognized that in Roper and Graham and Miller and Jones. But the question is it developed enough? And
Counsel, I have a question though.
Yes, they are.
Can you help me with this whole issue of separation of powers in the legislature versus the court? Can you address Sister Counsel's contention about SORA? You know, the court did strike down SORA as unconstitutional. How would that differ from that here?
Well, clearly the court has the ability to strike down a law as unconstitutional. What happened in SORA, however, is that the legislature, you know, SORA was passed in 1995, or it became effective in 1995. It was amended several times, and during the course of that, it changed from a regulatory scheme to something that this court has declared was punishment. And so at that point, the issue was raised before the court, and the court determined that it was unconstitutional as an ex post facto, punishment against people who had been convicted before the statute was amended. The statute here, in Michigan, it's been first-degree murder has been punishable by life without parole since the beginning of the state, since we outlawed capital punishment. So while the court does have the authority to say a law is or is not constitutional or punishment is excessive under Article 1, Section 16, nothing has changed with this law. The only thing that's changed, and it's been talked about, is that the science has developed, or the science now has determined, that brains develop at a certain rate. This was the case. This was true before we knew about this science, and it's true now, and it's going to be true as time goes on. And it is a sliding scale. It is a slippery slope. But the penalty of life without parole in sentencing an adult for first-degree murder is not concerned with rehabilitation, clearly. They're not coming out of prison. They're going to serve their life in prison. It's a punishment. It's to can't think of the term, to keep other people from, it's a deterrent to keep other people from committing that same heinous crime, and it's a deterrent against that defendant from committing that crime.
Isn't all that the defendant is asking is to be afforded the opportunity or the process? I mean, because that sentence, all of those factors could in fact merit a life without parole sentence, correct? And what they're asking for is a process, a procedure to actually consider the offense and the offender before imposing whatever sentence it may be. So the line drawing, and are they closer to 18 or not, or are they the unique 18 or 20-year-old who actually is as wise as a 30-year-old, or all of those things are things that we should be, that should be given to the judge in deciding in a particular case.
Right, so we do that for juveniles, but I would say, Justice Cavanagh, that's a policy decision, and I say it because of this. So it's a policy decision whether the evolving standards of society have determined that young people of some age are due some additional consideration because they're young and they're impetuous and they can't control themselves and they do things that get them into deeper trouble because of the characteristics of their age. Well, the Supreme Court under the 8th Amendment drew that line at 18. Our legislature, when they changed the statute, providing for additional procedure, they could have gone above 18, but they didn't. They drew the line at 17 and under, juveniles. And as Mr. Boffman argued previously in the last case, that the legislature is more appropriate. It's created to reflect the will of the people. The representatives in the legislature and the senators are directly responsible to their constituents, and that's the purpose. They are supposed to reflect the will of the people and the standards and the evolving standards. Now, it is true, though, that the court has the ability to say that something's not constitutional, that it's in review of the legislative enactment. But if it's unconstitutional to have a life without parole sentence for someone who commits first-degree murder as an adult, then that opens a can of worms bigger than having additional hearings every time there's a young adult, and depending on what age the court might choose, that will have this special procedure. As Mr. Boffman said, there's about 2,000 offenders in the state Department of Corrections right now that committed first-degree murder under the age of 25. And
Do you have any, do you know, just, by chance, how many offender, or how many cases when after Miller and this Michigan was required to enact a statute to actually make sure that it was constitutional, which required a resentencing or the prosecution deciding that? Do you have any idea, are we in a much smaller category of cases, or is this, because I don't think the world has spun off its axis from having to do that. I'm just trying to put it in terms of what would a decision like this now, how would that be different from what happened in relation to the Miller?
So I don't know definitely, but my recollection is it's somewhere around 325, 350 juveniles that had to be resentenced. And here we're talking about 1,890
magnitude
inmates
of order greater.
that would have to have a new hearing. And it isn't as simple as just having a hearing. Millions of dollars are being expended. Defense, most or many, represented by SATO, are obtaining expert witnesses in every case, a mitigation specialist, an expert to do a psychological evaluation and or testimony. We're being inundated as prosecutors, trying to keep up. These hearings aren't over. We haven't even been able to do all of these yet. So,
is that a price, though, that society's willing to perhaps shoulder in light of the fact that we're not, subjecting undeveloped brains or people who have the potential for rehabilitation to a process? Is that part of what our justice system does?
Well, I see the point that you're making, and I think it is true that the concern, that's not the primary concern, but it is under the retroactivity analysis. It is one factor that, and we didn't brief this issue, but I know that, it was mentioned that the purpose of the new rule would be one reason, but also reliance on the old rule. And there's been great reliance on the fact that someone who commits first-degree murder is going to go to prison for life. There's been a great reliance on that rule, and the effect that changing the rule has would be immense. So even if the court were to come up with a new, or determine that sentencing adults at whatever age, 18 or 18 to 25, is unconstitutional and they all deserve a hearing, if it's made retroactive, that's a huge expense and a huge burden on the court system and the prosecutors and the defense, everybody, and on the government for monetary reasons.
And victims.
And victims too. And thank you for making that point, because, I mean, it's
I'm
hard
sorry, now
enough-
we can't hear you, and Justice Viviano made me do that.
At least I'm lighted here
Something I
for the last 5 minutes.
Oh, that helped.
I feel like we're in a closet.
Sorry, we threw him off.
You can have some extra seconds, go ahead.
That's right.
I
get
had
it.
mentioned that
I get
it also has an effect on victims.
Yeah,
I think is where you're
yeah,
at.
so the resentencing of juveniles has had a huge effect on victims. It reopens the case. They don't know what's gonna happen, there's a lot of uncertainty, and they feel like their loved one has been killed, and the defendant, who they knew what penalty they got, is now getting the opportunity to get out of prison. And to victims, that's a huge thing. In this case, Mr. Jones Dickerson, he gets no parole. He's dead. His family gets no parole. Their child or brother or cousin is deceased. But, you know, it's hard for a victim to understand that a defendant who's done this, who's, you know, both Mr. Harris and Mr. Parks orchestrated this, they may get another chance and they may get to come out of prison. I mean, it is re-victimizing the victim.
But that is true in any type of resentencing, correct? I mean, and we don't say, well, yes, you have an unconstitutional sentence, but it's gonna be hard on a lot of other people, and therefore you're just gonna have to bear the burden of that unconstitutional sentence.
I think it's a factor to take into consideration if it's, there's a thought that to make it retroactive. I think it does. And it is hard on victims in any resentencing, you're right, but it's even harder when the assailant has been convicted 10, 15, 20, 30 years ago. That upends their life. It brings it all back up again, and the person's back out on the street, potentially. Are there any other questions?
Thank you, counsel.
Thank you.
Your Honor, if Mr. Parks were to be resentenced and this court were to find that mandatory life without parole is unconstitutional and disproportionate as applied to young adults like Mr. Parks, the trial court at resentencing can look at the circumstances of this offense and decide what sentence to impose. They can also look at the other relevant Miller factors: Mr. Parks' age and his immaturity at the time of the offense, his family and home environment, the incapacities of his youth as it relates to being able to participate in court, and his potential for rehabilitation. And from there, the trial court could decide to impose life without parole, or they could choose to impose a term of years sentence. As Justice Cavanagh said earlier, all we're looking for here is a process. We're looking here for a chance, and Mr. Parks is completely eclipsed from being able to show any of these factors, to being able
Counsel,
to show...
my biggest challenge with this, and you're doing an excellent job, but my biggest challenge with this is the cutoff, is that at a certain point, someone's going to be out of luck. It's just the way it goes. And the question is, when is that? And the argument that is kind of just being put forth here is that everyone has come to understand and appreciate that 18 is the term of age. You become an adult. You recognize as an adult. You can serve in the military. You can vote. Like 18 is just kind of widely understood as the age that you are an adult. You have these new responsibilities. You have these new obligations. You also have these new opportunities. And the question here is that you're arguing that, look, the science is basically saying that the development of the brain goes until 25. And I think what Justice Viviano, I mean, basically I'm just kind of consolidating all of this, is that I think the biggest challenge here is when's the cutoff? And the question here is that we're not talking about total, we're not talking about juveniles. We're talking about an 18-year-old. 18-year-old's an adult. And you're extending that to say that, well, no, they're 18, but yet, they're still a young adult now, and that's where I think people are really having a challenge with this, is to know, like, okay, now it's 25, and then at a certain point, like, it's 25, and then there's going to be a 26-year-old who's going to come and say, well, but I missed it by a week, and just saying there's got to be, it's hard, I realize it, but there is a cutoff, and the legislature determined what that was in deciding what these sentences were going to be, and whether we agree or disagree, legislative decision, and how do we implement that and know where the cutoff is?
Your Honor, I see my time has expired. May I?
But I gave you a
respond to
very
your
long question, so please answer, yes.
Your Honor, the cutoff is 25. The cutoff is 25 here because of the science. And yes, 18 years old is the age of majority in this country. But as the science has evolved, so has this country's perspective on the protections that young adults like Mr. Parks are entitled to. For example, expanding HITA to include those up to 26 years old, expanding the drinking and smoking age, many states have expanded the concept of what a youthful offender, quote unquote, would be, and expanding that up to 21, 26 years old. And so it's important to look at all that and also look at what other states are doing. For example, Washington has decided that mandatory life without parole is unconstitutional as applied to those 21 and under. This court did feel more comfortable drawing the line at 21, given what other states have done, then certainly it may do that. But all we know is that the line is certainly beyond 18 years old. According to brain development, 18 is an arbitrary line to draw here.
Now I'm confused, because you say the science says 25, but if we felt more comfortable, we could draw the line at 21. That seems to just call back the question of whether or not this is something that the legislature should be deciding. If we can pick any number from 18, 19, 20, 21, all the way up to 25, and other states are picking other numbers, that it makes it seem like something that we shouldn't be doing. Either we follow the science and we use that to make a decision, or we don't.
Yes, Your Honor, and that's why our argument today is that the line should be cut off at 25. But I also do have to recognize that other states have seen the science maybe a little bit differently and have chosen to cut the line off at 21, for example. But the science here is very clear. The young brain continues to develop in a very significant manner until 25 years old. And so that's why our argument today is that that line should be cut off.
So those other states that you raised that put the cutoff at 21, what did they see differently in the science?
Your Honor, specifically with respect to Washington State, who drew the line at 21, they looked at defendants who were 19 and 20 years old. And so it was not the question before them whether someone over the age of 21 should be considered in the rule. They were only looking at younger defendants within that young adult framework.
So they didn't look at the science and disagree with it or read it differently. It was because of the case that was before them, they just decided that case, and that's where that cutoff was at that point in time.
Yes, Your Honor.
Okay, thank you.
Thank you, counsel. The case will be submitted. That concludes today's case call. We will be back here tomorrow morning at 9:30.